Hello and welcome to today's update on a major development affecting federal employees across the United States. I'm Tom Spiggle, and today we're talking about President Trump's newest executive order, Return to In-Person Work. This order could have significant impacts on thousands of federal workers currently enjoying the flexibility of remote work. The executive order states, quote, "Heads of all departments and agencies in the executive branch of the government shall, as soon as practicable, take all necessary steps to terminate remote work arrangements and require employees to return to work in person at their respective duty stations on a full-time basis, provided that the department and agency heads shall make exemptions they deem necessary." This sweeping mandate signals the end of remote work for federal employees unless specific exemptions are granted by agency heads. But what does this mean for you if you're one of the many federal employees working remotely? Let's break it down. First, let's address the obvious question. Will you have to move to your duty station? If that duty station is in Washington, D.C., will relocation expenses be covered? Unfortunately, the answer to these questions aren't fully clear yet. Here's what we do know so far. Under current federal guidelines, if your agency requires you to move to a new duty station, they may offer relocation assistance. However, this will depend on your agency's budget and policies. If your duty station hasn't changed and you've simply been working remotely, relocation costs may not be covered, leaving you responsible for moving expenses. Now, let's talk legality. Can your employer legally require you to relocate or to report to an office in person? In most cases, yes. Federal agencies are within their rights to require employees to work at their designated duty stations. However, certain exemptions may apply, especially if you have a documented need for remote work. The Americans with Disabilities Act, or the ADA, generally does not apply to federal workers. Instead, federal employees are protected under a different law, Section 501 of the Rehabilitation Act of 1973, which offers similar protections against disability discrimination and requires federal agencies to provide reasonable accommodations for employees with disabilities. The ADA primarily applies to private employers, state and local governments, and public accommodations. However, the Rehabilitation Act ensures that federal agencies are held to equivalent standards as those imposed on private employers under the Americans with Disabilities Act. Keep in mind, not all accommodations requests are granted. So, what should you do if this executive order affects you? Here are some key takeaways. Stay informed. Monitor announcements from your agency leadership for guidance on how this order will be implemented. Review your duty station requirements. Check if your current position requires you to work in person at a specific location. Consider your options. If relocation isn't feasible or remote work is critical to your situation, consult with your agency's HR department to explore exemptions or accommodations. Know your rights. If you have concerns about the legality of these changes, consulting an employment attorney may be a good step to understand your options. The future may feel uncertain for federal employees impacted by this executive order, but remember, you're not alone. If you have questions about your legal rights or need guidance navigating this transition, we're here to help. Visit our website for more resources or to schedule a consultation. Thanks for watching and stay tuned for updates as we continue to monitor this developing situation.